I'm Michael Popok. You're on the Legal AF YouTube channel. Hit the blue subscribe button. It helps grow this pro-democracy channel. I want to do a deep dive into the ruling that just came out of the Second Circuit Court of Appeals in favor of E. Jean Carroll, who was sexually assaulted and obtained two separate judgments against Donald Trump. One for defamation he conducted while he was president of the United States in 2019, the first time, and one for defamation he did against his sexual assault victim after he was president in 2020. Those two judgments combined are almost $90 million plus interest, taking it to almost $100 million. And now a Second Circuit Court of Appeals has ruled in favor of E. Jean Carroll on the $5 million part of that. But there's two things buried within the 70-page ruling that I wanted to resurface here and talk about, because it just shows you the depravity of Donald Trump's position. Depravity brought by three lawyers who are now on their way to being promoted by Donald Trump inside of his administration as some of the top three lawyers in America. But here, in their civil capacity, in their criminal law capacity, they just suffered a devastating loss by the Second Circuit Court of Appeals. I'm talking about Todd Blanche, who's going to be likely be the Deputy Attorney General of the United States, the number 2 position in the Department of Justice under what could be Pam Bondi, the former Florida Attorney General, his deputy, who's going to be Emil Bove, and John Sauer, who's likely to be confirmed as the 10th Justice of the Supreme Court. That's how they jokingly refer to it, as the Solicitor General of America. But they just lost the Second Circuit. Now, buried in that order are the two ridiculous positions taken by Donald Trump, completely rejected by the Second Circuit. It has to do with two primary witnesses against Donald Trump who successfully showed a jury of 9 people, 9-0, that they too were sexually assaulted by Donald Trump, that they too had unwanted sexual contact with Donald Trump. And that was used under a certain rule of evidence to show that Donald Trump had a propensity to do this to E. Jean Carroll, further bolstering the credibility of her case. The two witnesses, one is Jessica Leeds, and the other is Natalie or Natasha Stoynoff. Okay, Leeds and Stoynoff. Let's dive in. For Leeds, Donald Trump actually had the temerity, actually had the balls to argue that what she alleged happened to her on an airplane, where she was had the misfortune of being upgraded to first class, only to have to sit next to Donald Trump in a serial groping, who groped her, sexually assaulted her, her testimony during a flight, including trying to put his hand up her skirt and touching her on her breasts against her will. He said, well, when that happened, that wasn't a crime. Listen to the thought process of the person just elected president of the United States. His main defense to keep the Jessica Leeds testimony out from the jury was that even if you accept what she says happened to her, it wasn't a crime. To which the Second Circuit Court of Appeals, and I'll read it to you in a minute, responded, it was a crime then, it's a crime now, and it always was a crime to do unwanted sexual conduct and contact on an airplane or anywhere else. It's called assault. And assault on an airplane, as we all know from watching people post-COVID act out against inappropriately against crews and staff, we know that's a crime. For the second testimony, in which Natasha Stoynoff, then a reporter for People magazine, who had the misfortune of being assigned the story of the new marriage of Donald Trump and Melania, to go to Mar-a-Lago to do a puff piece for People magazine about it. And as soon as Melania left the room, her testimony to the jury was that he pushed her up against the wall, jammed his tongue down her throat, sexually assaulted and molested her, said that she was going to have an affair with him. It was going to be the best sex of her life. And on top of that, she also claims that all of that happened, of course, after the doors were closed in a private place. This is consistent with E. Jean Carroll's testimony that she was brought into a dressing room under false pretenses at Bergdorf Goodman department store in New York, under the pretense that Donald Trump was shopping for lingerie for a girlfriend of his. And then he forced her, shut the door of the dressing room, pushed her up against the wall, and then sexually assaulted her. And inserted something into her vagina. It's just the jury couldn't figure out whether it was his penis or something else. So it was sexual assault, right? For the Stoynoff testimony, his lawyers argued to the Second Circuit Court of Appeals that the only way that could come in is if it took place at sea, in a maritime jurisdiction, or some other federal, like an army base, which is a complete misreading of the statute that deals with the admissibility of this type of evidence and the type of crime that's been committed. You know, his argument was, I'm not making this up. I'm going to read it to you in a minute. His argument was, Mar-a-Lago is not at sea. It's not maritime. It's not a boat. And so I could freely assault Natasha Stoynoff to my heart's content. And it's not a crime and it can't be used against me as evidence. Do you see why the Second Circuit Court of Appeals rejected throwing out the judgment in favor of E. Jean Carroll and giving Donald Trump a new trial with these kind of arguments? So let's start with Leeds. Here's what let me read to you from pages of the order. 3-0 against Donald Trump. This is what they said. The Second Circuit Court said about the Leeds testimony. Jessica Leeds testified that she was on an airplane flying to New York in 1978 or 1979 when a flight attendant came down the aisle to ask if I would like to come up to first class. She testified that she sat down next to a man sitting at the window. So Trump had the window seat, who introduced himself as Donald Trump. The two chatted. After their meal was served and cleared, Mr. Trump suddenly decided to kiss her and grope her. Ms. Leeds testified at trial, quote, it was like a tussle. He was his hands and he was trying to kiss me. He was trying to pull me towards him. He was grabbing my breast. He was like 40 zillion hands. It was a tussling match between the two of us. And it was when he started putting his hand up my skirt that kind of gave me a jolt of strength. And I managed to wiggle out of the seat and went storming back to my seat and coach. On cross-examination, she further explained, okay, and then according to you, he at one point put his hand on your knee. Answer, he started putting his hand up my skirt. Okay, on your leg and up your skirt? Correct. Remember, this is when Alina Habba was handling this case for Donald Trump. On redirect, she explained why she got so upset. Quote, men would frequently pat you on the shoulder and grab you or something like that. And it's not that serious and you don't. But when somebody starts to put their hand up your skirt, you know they're serious and this is not good. Trump argued on bottom of page 29 that Rule 415 about letting in this type of evidence does not apply because he contends that the jury, that what she described does not constitute a crime at the time that the conduct occurred. Yeah, like back in, what year was this? Back in 1981? Let me get it right. Back in 1978 or 1979, you were just able to freely grope, put your hand inside a woman's vagina, and it was not a crime. That was Donald Trump's argument. To which the court reminded Donald Trump, on page 30, we conclude that Leeds' testimony was properly admitted. First, Mr. Trump's alleged conduct towards Ms. Leeds was a federal crime at the time it occurred. Second, the Leeds testimony was admissible on the ground that Ms. Leeds testified in an attempt to engage in that conduct. And because we conclude that Leeds' testimony was admissible, it's coming in. We begin with the requirement, the court went on, that the other act be a crime under a federal or state law. Mr. Trump argues that the alleged act had to constitute a crime at the time it was committed. We need not decide this issue because we conclude that the alleged act clearly was a crime at the time. In 1978 and 79, this is page 31 of the order, just as it is now, it was a federal crime to commit a simple assault on an airplane. And on this record, a jury could have reasonably found that Trump committed a simple assault against Ms. Leeds. And then they cited the parts of the federal statute about simple assaults on aircraft. And then let's move to Natasha Stoynoff, also a key part of the case against Donald Trump and one that was the basis of his appeal. Here, this is on page 36 of the new decision that just came out. Natasha Stoynoff testified that in December 2005, when she was a reporter for People magazine, she was on assignment to Mar-a-Lago. She was there to do a story about the first anniversary of Mr. Trump's marriage to Melania and the arrival of their son Barron. Oh, I forgot about the Barron part. Stoynoff was at Mar-a-Lago for most of the day, conducting interviews with Trump and his wife. During a break between interviews, Mr. Trump told her he would like to show her a painting that he had in this really great room in the house. This sounds like a scene out of The Graduate, Mike Nichols' famous movie with Dustin Hoffman, where Anne Bancroft tries to seduce Benjamin, the character that played by Dustin Hoffman, by telling him, "Would you like to go see my daughter's oil painting in the bedroom?" So right out of the pages of The Graduate, here's Donald Trump saying, "I've got a great painting in this really great room in my house. Why don't you come, let me show you some etchings." Mr. Trump then led her to her room in a different part of his residence. Once they arrived at the room, as Ms. Stoynoff described at trial, quote, this is her testimony from trial on page 37, "I went in first and I'm looking around. I'm thinking, wow, really nice room. Wonder what he wants to show me here. I hear the door shut behind me. By the time I turned around, he has his hands on my shoulders and he pushes me against the wall and starts kissing me, holding me against the wall." She further testified that she tried to push him away, but he came at her again and tried to shove him. She tried to shove him again. That Mr. Trump was kissing her. He was against her and just holding her shoulders back. The encounter ended when Mr. Trump's butler came into the room. Thank God the butler was there. Immediately afterwards, she testified that Trump told her, "Okay, we're going to have an affair, don't you? Don't forget that. Don't forget what Marla told you. Best sex she ever had. We're going to go for a steak. We're going to go to Peter Luger's. We're going to have an affair." Now, Mr. Trump challenges, this is the bottom of page 37, the district court's, that's Judge Kaplan's admission of the Stoynoff testimony, primarily because he says it did not happen, this is on page 38, it did not happen, page 39, in a maritime place, a special maritime and territorial jurisdiction of the United States. That's not how that statute works, Trump. That's what the federal court told him. Mar-a-Lago is within the federal jurisdiction, and your sexual misconduct with her, it should have been admitted. And they also said that it was not an abuse of discretion by the trial judge to admit it, because it found properly on page 38 that those actions, inviting Ms. Stoynoff to an unoccupied room, closing the door behind her, and immediately engaging in non-consensual kissing, despite her resistance, suggested a premeditated plan to take advantage of the privacy and to do so without regard to Ms. Stoynoff's wishes. The court went on to say, "We agree," and further conclude that the jury could have reasonably found that Mr. Trump took a substantial step toward the completion of this premeditated plan when he allegedly closed the door, forcibly held Ms. Stoynoff against the wall, and kissed her, despite being pushed back, and that this was very similar to what had happened with Ms. Carroll, therefore properly admitted into evidence. I just wanted to point out that the three guys and they're all guys, who are going to be the top three lawyers for Donald Trump, filed papers to say that it was not a sex crime or a crime, that when Donald Trump abused a woman on an airplane and assaulted her on an airplane, when it was, and that he couldn't be held accountable for sexually assaulting Natasha Stoynoff, the People magazine reporter, because he wasn't at sea when it happened. These are the people that are going to be making arguments before the United States Supreme Court and in courts around the country. This, again, is the reason the federal judges have to have a jaundiced view of anything that comes out of the mouth of anybody within the Trump administration, including its main lawyers and the FBI. Nothing should be taken at face value. Everything should be put to the test and their feet to the fire as federal judges do their job to secure democracy. I think this is an important commentary and a wake-up call for federal judges as well, as you listen to the ridiculous, depraved arguments being raised and rejected by Donald Trump's chief lawyers. I'm going to do all this kind of analysis. I do it in a couple of places. You're here on the Legal AF YouTube channel already, so you must want to be here. Hit the subscribe button. We're trying to get to 500,000 by the first quarter of 2025. In addition to that, besides what I curate here on the Legal AF YouTube channel, catch me on Popok Live on Tuesday nights at 8 p.m. on Midas Touch Network, 8 p.m. Eastern Time, Popok Live. Wednesdays and Saturdays, Legal AF, the original, the OG, at the intersection of law and politics. Wednesdays and Saturdays at 8 p.m. Eastern Time, also on the Midas Touch Network. Great news there. We are top 8 in the world, regardless of genre, globally, for podcasts, based on views and downloads. Number 1, Joe Rogan. Number 2, Midas Touch. Number 3, Legal AF. That's because of you. We are people-powered. We are Midas Mighty and Legal AF are powered, and we can't do it without you. So until my next contribution to all things Legal AF, I'm Michael Popok reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.